Now, not too long ago, they passed a law here locally where you could no longer discriminate based upon income source, meaning you had to accept Section 8. So, for
Correct.
those of you watching, hopefully that's not news for you, but you must be open to Section 8 tenants, and hopefully you're not putting ads that say no Section 8 allowed or something like this, because you would be breaking the law. But what about this term now, essential, right? Given the health concerns we've had here lately, and we've seen those that were essential workers and those were non-essential. Can you make that judgment call as a landlord as you look at their current employment and assuming a lockdown in the future, would this person be considered essential? Do you see where you could run into an issue there?
I think if you approach that correctly, it's a great idea. And the reason I say that is obviously essential workers are still working, right? They're considered working. It's a double-edged sword. It depends on what the essential worker is. I will, and let me clarify what I meant by that. On the one hand, yes, it's true. Essential workers they continue to work in these kind of lockdowns, et cetera. You also want to give consideration to, okay, what are they? Are they exposed to COVID in an environment? Does their job give them greater exposure to COVID? Am I putting other people in the property at risk? Now, I would caution your members, do not decline people because of that. And I'm not going to go in this interview, I'm not going to go into details about how to answer questions, mainly because I know that this channel gets put out into the public, and I know that the tenants' rights advocates look for interviews like this, and they look to see what our strategies are, and they want to counter them. Also, they're looking for potential lawsuits against your clients. If your clients would like to call me and ask me about, okay, how do I properly respond? Things I want to say, things I don't want to say, we can do that. I'd set up an hourly rate with them. It'd probably take about 30 to 45 minutes to give them a general overview of what they can and can't say and what they can and can't consider. I'm happy to do that, but I don't want to go into too many details on this interview. I will say this, there's nothing against asking for an employment letter from their employer stating a couple things. One, that they're anticipated to remain full-time for the next, let's call it 12 months. Two, that during the COVID period, they were or were not furloughed. Three, if they were furloughed, was it down to a part-time, or how many hours did they lose? There's nothing that prohibits a landlord from asking those questions as long as they're done in an anti-discriminatory way.
Second here, what requirements would you ask for when a tenant is all cash? In other words, they have no documented income.
All right, so that's it. That's another great question. You just brought up a great point. As you said, you cannot discriminate against the source of income on any level. But that doesn't mean that how do I say this clearly? Under the right circumstances, you can ask for bank statements to demonstrate regular deposits and withdrawals. Just because you can't discriminate against source of income doesn't mean you're not allowed to require a source of income, a legal source of income. So for people who are paying cash, one of my criteria would clearly be you've got to be able to document, where this cash is coming from. I mean, when I go to the bank, it's funny. When I go to the bank, if I want to make a large cash deposit, I have a questionnaire I have to sign at my own bank because they're concerned about money laundering, right? Mm-hmm. So, and the whole banking industry has all these regulations that are designed to prevent money laundering. There shouldn't be that much of a difference in a landlord-tenant relationship. Like I said, you can't discriminate against source of income, but there's no reason you're not allowed to ask them to verify that they actually do have a source of income. Bank statements are a great way to do it. They can redact or black out all the account numbers and personal information. But what I want to see is I want to see dates, and I want to see the amounts deposited. And I want to see that I want to look at what's the median deposit, right? What's the difference between their greatest deposit in the last 12 months or 18 months and their lowest deposit in the last 18 months? Are the deposits coming on a regular basis? If they're coming on a regular basis every week, this individual is depositing no less than whatever it is, $500, no more than $1,000. and they're telling me they work some sort of an hourly job that's under the table, et cetera. I'm not allowed to discriminate against that. Although now that I think about that, if it's being paid under the table, I'm not sure that's a legal source of income. And you might be able to discriminate against that and say, I can't accept you if you're paid under the table. But putting that example aside, if they can't really document it with pay stubs, then I want any sort of documentation that shows me they've got a regular source of income. But that's going to come back to also their employment. If one of my criteria is you have to have a verifiable good employment, meaning a good referral, for the last year at the same employer, which is a perfectly acceptable criteria. They're telling me they're getting paid cash, and I call up their employer and verify, hey, I just want to verify they work here. Yes, they work here. Do they work full time like they claimed? Yes, they work full time. Do you pay them cash? No, I pay them a check every 2 weeks. Okay, there's a red flag for me because they're telling me all they have is cash, right? If I can't verify their employer, and I can't verify that the source of the cash is from a legal source, I don't have to accept them as a tenant.
Do we have any enforcement power renting to a new tenant if they start violating the rental agreement for items other than non-payment of rent?
So the short answer to that is yes. At-fault evictions are specifically permitted under AB 3088. But as you alluded to, or you stated in the beginning of the interview, double check whether the local moratorium is still in place and prohibiting evictions. Also, AB 3088 includes a new section on retaliation. So be careful. When they wrote the law, they knew what, or at least they suspected what they thought the landlords were going to do. They're going to say, well, you owe me COVID rent, but you're violating the lease over here, so I'm going to evict you on that. And so they really beefed up the retaliation law on a temporary basis. It'll go away, I think, at the end of AB 3088. But the point is, yes, you can do at-fault evictions for something other than non-payment of rent under AB 3088, provided your local moratorium doesn't prohibit it. For example, in Los Angeles, the city of Los Angeles prohibits all evictions, essentially, except for health and safety evictions. So even though under AB 3088, it allows evictions for violations of the lease, your local moratorium may not. Now, where your local moratorium does allow it, as I said, be very careful, document everything. And I might even suggest that in order to circumvent, or not circumvent, but to defend against a claim of retaliation, that you might want to send the tenant a warning letter that can be introduced into evidence. So let me give you an example. Let's say the tenant hasn't paid all of their rent during COVID, all right? But the tenant has also moved in several unauthorized occupants that are creating problems on the property. And you're in a jurisdiction where the moratorium does not prohibit that type of eviction, then you could go ahead and do that eviction. However, you can bet that the tenant, when they file their answer, is going to raise retaliation. And they're going to come to court and say, it's not really about the unauthorized occupants. That's nonsense. He's really just evicting me because I owe him rent for the COVID period. And like I said, they really beefed up that law. And then now the burden's on the landlord to prove that that's not true. So what I would do to document those situations, any sort of a violation of the lease, other than non-payment of rent or any other monetary non-payment, I would send a letter and say, hey, look, you've allowed these people to occupy the property, and you can even do it with the notice if you want. You've allowed these people to occupy the property. I'm giving you a warning to remove them from the property or stop breaking the lease in whatever way you're breaking it, and document it very well and give them a certain amount of time. If you don't stop by, X amount of days, or you don't remove the people by X amount of days, I'm going to serve you with a notice to remove the people. And if you don't do it then within the statutory time period, I'm going to file the eviction. You also, in that case, you'd want to get pictures. You'd want to try to follow the unauthorized occupants to their car, take pictures of their car at different times of the day and night to prove they're living there. And then once you have that letter and you're standing in front of a judge and the tenant is screaming, oh, this is just retaliation, you can present that letter as evidence to the judge saying it's not retaliation. I notified them in advance. I gave them an opportunity to cure it even before I served them the cure covenants or quit notice. They just refused to do it. And here's my pictures after that warning letter showing that they never removed the people. So yes is the answer. You can do it. But in this environment, I would really encourage everybody to document the heck out of everything.